where it says that the traveled portion of Buck Road as it currently exists shall not be widened along the side that abuts the Ruddy property lot.
Okay.
There is a small triangular portion of property that abuts the Ruddy lot. That ownership is actually Mr. Salke. In the initial complaint, there was a claim for adverse possession on that small triangular portion. The claim for adverse possession was withdrawn because of the agreement that Buck Road would not be widened at that location. It's my understanding that Mr. Salke wishes to widen the road at that location, that it still abuts the Ruddy property lot. And that was made very clear on the record in the transcript that the road along the Ruddy lot would not be widened any further over than it currently exists. So I believe that's the primary and most material difference between the two orders, and that's the primary issue that the parties weren't able to come to terms to after the agreement was placed upon the record. Mr. Blumberg may have a different opinion, but I don't think so. Judge, the only other issue that we're going to have is that.
Well, I'm going to stop you, Mr. Edwards, because, like I said, I'm going to go through it
Okay.
point by point. Hear each party's determination and then rule upon it. Mr. Blumberg, what's the primary issue first? What's the first issue?
Well, Judge, let me address the issue that Mr. Edwards just raised, because if you look at our proposal, it says it is agreed that the travel portion of Buck Road that abuts the Ruddy property shall not be widened toward the Ruddy property. In consideration of the above, the T-posts along the Ruddy property shall be removed within 14 days of the entry of this order, and no obstacles be placed on the platted road. That's taken word for word from the transcript.
Well, what's the transcript page? I've got a copy of the transcript, but I don't have a page. You do.
Yeah, well, let me, yeah, if you come, sorry, give me a second, I'll find it. Highlighted it here. Okay, if I may, this is on page 8 of the transcript.
All right.
And about starting on line 10, it says there was an agreement that the travel portion of the current drive as it abuts the Ruddy's house will remain where it's at. It won't be widened. At least on the Ruddy side, it will not be widened any further. Currently, there are some metal T-posts along the edge of that road. We've agreed that those T-posts will be removed and some type of fencing material will be placed, but it won't be any closer than 2 feet from the traveled portion of the road. That's when we went outside and we clarified that. I don't know if the court probably has no recollection of that, but the parties step outside to clarify that, and we did. So the language on page 8 was adopted in my proposal, and I think it's totally consistent with what the parties placed on the record.
Why is it not consistent, Mr. Edwards?
Judge, there was a request that the Ruddys have a storage shed and a wood pile that's actually on the portion of the platted road that was there even prior before they purchased. During our negotiations, trying to get an order entered, Mr. Salke was demanding that those be removed off of the platted portion of the road. They don't interfere with the traveled portion. And so when they put in,
you're talking now about a storage shed. We're not talking now any longer about the traveled portion of the road. I want to take it one by one.
Yeah.
Mr. Blumberg decided to to the agreement that you were placing on the record. Why does he have it wrong?
Are you asking me, Judge?
Yes.
Because the language says no obstacles be placed on the platted road. The platted road extends beyond the improved portion of the road.
So here's the easy thing for the court to order. One of you or both of you are going to prepare an updated judgment, and instead of having whatever either one of you suggested for that portion of the agreement, you're simply going to have the entirety of line 10 through line 19 from page 8 of the transcript included in the order. That's the language. That was the agreement. That was what was stated. That's it. Nothing less, nothing more.
Judge, that language was slightly modified when we came back from the record.
If it was, then whatever it was modified to, the exact transcript language, period, no more, no less, is all that's going to be in the order, and all that's going to be in the order, meaning not only what's going to be in the order, but all of it will be in the order, if it was modified. And the two of you are smart enough and good enough at looking exactly at what you're both looking at, that I'm sure you can find if there was any modification to that line 10 through line 19 on page 8, you'll find it, you'll identify it, and that's what's in the order. If it wasn't modified, the entirety of line 10 through line 19 from page 8 is that portion of the order.
Fair enough. I thought that's what I had done, or at least attempted to do, but that's pretty clear, Judge. I know what you want done. We'll do it.
Judge, the only other issue that we have is that the part of the agreement allows the Ruddies to put in like re-rod in the ground to mark the travel portion of the road just under the surface. When we had this hearing back when it was seasonable, you see what the date was. The ground wasn't frozen as it is now, and as the court knows, it's going to be impossible to stick anything in the ground. This was back on August 15th. Here we are, 8 months later. It's impossible to put the re-rod in the ground right now because of the frozen. What I'm asking is that the T-posts remain until the ground thaws, and then the re-rod can replace the T-posts. There's no other way. There's no other way to document, right? Especially now in the wintertime, there's no other way to document exactly where the improved portion of the road exists. Mr. Salke continues to try to plow and widen the road during the wintertime with his plow, which then gives the appearance that the road is, the improved portion is wider than what it actually is today.
Mr. Blumberg.
Judge, the T-posts are a major problem for snow removal. In fairness to the court, you've never seen this road. This thing is incredibly not very wide. Plow trucks have a hard time getting through there. Emergency vehicles probably couldn't get through there at all. Those T-posts, if they're allowed to remain, cause a real problem for snow removal. They're going to get hit.
Here's the court's view. And it's unfortunate that the attorneys and the parties couldn't get language soon after August in order to accomplish everything that was said. But the agreement, and I found the secondary page where you made the clarification, Mr. Edwards and Mr. Blumberg, in case you need it, for the first part of the court's order, and that was on page 10, starting at line 6 and going all the way up to line 12, which said there will be no split rail fence. What will happen is the parties will put in survey markers like re-rod just below the surface and so forth. That's fine. You can do that when the spring comes, but you can't do it now. Or you can, because you're out of the way. But the T-posts were still a part of the agreement that were placed on the record that they were going to be removed. This wasn't my agreement. It was part of the parties' agreement that the T-posts were going to be removed. So they're going to be removed. That was what the parties said on the open court record, understanding that it was going to be binding upon them. So T-posts are gone. I understand, Mr. Edwards, you can't get the re-rod in, is what you're saying. If you can get it in, that's fine. But if there's other issues with regard to a party's claim against the other and violating the agreement, I can take up to those issues if there's problems. But the question is, what should the order say? And the order should say what the parties agreed to. They agreed to take out the T-post within 14 days. So that's the order. Is there other questions between the parties or the attorneys regarding the specific language of the order that I need to resolve?
I don't think so, Judge. I'm not aware of any.
I believe that was the primary issue that was at concern that we discussed.
Okay. And again, that order then should get entered. If there's problems, I know the attorneys will bring it to me, a post-judgment motion to enforce or to clarify or whatever you need. I'm not saying I'm not going to address it. I'm just saying the time is not now. The time now is to get a judgment entered. And then ultimately we can deal with any problems if and when they come up. Mr. Edwards, anything further? And if not, as the prevailing party, Mr. Edwards and Mr. Blumberg, I guess you both kind of prevail. Neither one of you have it exactly right because I've said it has to be different. Who's going to coordinate and getting you judgment with the language I've indicated? Right.
I can try to do that, Judge. I'll get it over to Mr. Edwards for his review, and we'll make whatever changes that are reasonably requested. I think you've made it clear what needs to be in there, so shouldn't be a problem.
Mr. Edwards, any problem with that?
Judge, my understanding your ruling is that we're to quote from the transcript So it's hard to
Yes.
argue
If
for
you,
that.
Yep, and if you both want to include both the page from page eight and page 10, that's fine. If you agree that it's enough, it's clear enough on just one, that's fine. But the point is, if there's any clarification about specific language to be used, the easy fallback is a transcript. You caught it all. Okay, anything further?
I don't
No,
think so.
Judge, thank you.
Yeah, thanks for your time.
Yep, have a good day.